reserves the right and every person reserves the right to be heard and treated equally under the law, especially regarding decisions that individually impact them. My learned friends have erred in identifying that this decision is simply programmatic. As the High Court explained in Kiowa and West, 1985, Volume 159 of the Common Law Reports, page 550, paragraph 584 to 85, the greater the impact, the greater the content of fairness required. Your Honours, may my junior counsel and I dispense of formal citations?
Yes, I think that'd be good. But just before you do, was that the extract from Kieran West you're referring to, was that a majority of the High Court?
Yes, Your Honour. It was a majority ruling that when there is a greater impact, the greater the content of fairness is required in a procedural fairness matter.
Thank you, counsel. And yes, please proceed.
My learned friends have relied heavily on the judgment made in the Bear and Holmes and Victoria case, 2025. However, we submit that the facts in the present differ from those in the Bear case, and this distinguishes its judgment. In Bear, paragraph 110 to 113, the plaintiffs were treated as part of a broader class of tenants. However, in the present circumstances, the plaintiff has unique and profound individual interests. Her apartment has been structurally modified for her wheelchair use, and relocation risks significant disruption to her disability care. That shifts the decision's effect from general policy to an individualized impact. Furthermore, unlike in Bear, X is Indigenous, a traditional owner of the land, and the tower is embedded within a close-knit Wurundjeri Wurrung community. The demolition risks fracturing her cultural connections and distancing X from her community. Finally, the age of X also distinguishes this impact. At just 9 years old, the displacement from her home will have a more profound impact on her, especially since there is no way to guarantee that she will still be near her community or live in a home that is modified for her disability. This housing complex is far more than just a house. It is her sanctuary, a place where she is supported and able to live comfortably with her disability. To take away such a home is to upend the foundation of her life. Your Honours, the label programmatic cannot shield decisions that have a direct, profound, and individual impact on a young child's life.
Council, are you suggesting that the case in Bury there, it was a group proceeding there, that there were no children affected?
No, Your Honour, that's not what we're submitting specifically. In this specific circumstance, a child's rights have been specifically impacted, specifically a child who has disability and Indigenous ties to this apartment. And therefore, we submit that the harm that is being caused here is of a greater content and a greater level than what has been caused in the Bear case.
But I mean, doesn't that fly in the face of a broad policy decision? A broad policy decision will affect multiple people from different walks of life. Are you suggesting that any time that there's a broad policy decision, the affected members of any class, every single member should be considered individually?
Your Honour, if the broad policy decision impacts individually a protected right of a specific individual in that group, then yes, Your Honour, we do submit that that right should be protected.
Thank you.
This leads me to our second submission, that the hearing rule was breached. Your Honours, I shall address this breach in three parts. Firstly, timing and candor. Consultation began only after the defendant had already made up their mind. By September 2023, the decision to retire the towers was internally settled. By October 2023, demolition had been announced as the default solution. Within a single month, the defendant had both decided and declared its course of action. That is not consultation. Our learned friends assert that this decision had no immediate effect on the plaintiff's rights. However, the announcement of retirement sealed the fate of this plaintiff's home. To say her rights were untouched until actual displacement had occurred is Homes Victoria attempting to escape their fairness obligations by downplaying the finality of their announcement. As emphasised in the Moseley and London Borough case of Haringey, paragraph 25 to 26, fairness demands genuine consultation while proposals are still at a formative stage, with reasons and alternatives disclosed to those affected so that they can respond meaningfully. This principle has been echoed in Australian cases, such as the Brisbane City Council and Leahy and PJB and Melbourne Health.
Counsel, if you'll pardon the interruption, what do you say to the point that your learned friends have raised in their written case, which is that the legal rights weren't really affected because X remains a tenant and her tenancy isn't affected. She's just being moved from apartment A to, I imagine, apartment B, while the apartment block is basically revamped.
Your Honor, we submit that her rights are being infringed upon because the apartment she is being moved from is an apartment that has been specifically adapted to her disability. At this stage, the defendant has not disclosed where she will be moved to, and considering the scarcity and issues that are around public housing currently in Victoria, there is no guarantee that where she is being moved to will be adapted to her specific needs. And that is our submission that her rights are being impacted through this displacement.
Thank you.
Secondly, the formative stage requirement. The consultation that did occur was confined to relocation logistics, while the central question, whether demolition was even necessary, was never open for discussion. Fairness demanded that options remained genuinely open. Homes Victoria had to be willing to depart from a demolition decision if feasible alternatives were shown. It was clear that this willingness did not exist. The defendant had made their decision, and they expected the plaintiff to blindly follow. The expert report from Professor Malatesta underscores the profound human consequences of relocation. Based on past relocation programs, she advised that residents often face wide geographical dispersal due to the scarce and scattered public housing that is currently available. She explains that such a move is likely to fragment cultural connections and dissolve the informal support networks that these residents rely on every day. For the plaintiff, who is already a vulnerable 9-year-old, these are not theoretical concerns. Relocation would strip away the familiar structures that sustain her well-being, leaving her exposed to upheaval, stress, and the loss of critical social and cultural anchors. The impact on her is profound, tangible, and entirely preventable if alternative options had been considered.
I understood your earlier submissions, counsel. You suggested that no decision has been made as to relocation. The only decision that's been made is that there'll be a demolition of the towers, but that the respondent has not yet engaged in that discussion. Isn't that still a possibility here?
In terms of consultation, Your Honor?
In terms of finding suitable alternative accommodation for your client.
Yes, Your Honor, while that may be a potential, we submit that the demolition itself does not need to occur. And the expert opinions that we will be referencing throughout our submissions back this claim that there is a way to safely renovate this complex without demolishing and displacing the resident for the period of time that would be needed if they had to redevelop from the ground up.
But would your client be willing to accept an order from this court that the respondent is to find suitable accommodation, alternative accommodation for your client and your client only, whilst the demolition is occurring?
Your Honor, if the respondent is able to provide suitable accommodation for her disability and guarantee that she will still be able to have her cultural connection to the land, then yes, we would submit that we would be happy with that.
Thank you.
Thirdly, reasonable adjustments and the duty to inquire. This plaintiff lives with both autism and cerebral palsy. As this court emphasized in Matsu Katadao and Yarra City Council, substantive equality means that processes must be genuinely accessible, not just formally available. Where indicators of disability exist, there is a duty to inquire and ensure affected people can truly participate, as highlighted in Brooks and State of Victoria. Furthermore, the Castles and Secretary case emphasizes that when the state has control over the conditions of a vulnerable person's life, it carries a profound and active responsibility to protect their rights. This is not a passive duty. It requires careful attention, deliberate planning, and proactive steps to ensure that the person's well-being, dignity, and fundamental entitlements are genuinely safeguarded. Without such vital adjustments, any opportunity for the plaintiff to be heard was nothing more than an empty promise. Moving on to my third and final submission, that this breach was material. The defendant will submit that all these factors are minuscule and not material to the matter. But the law states that materiality is satisfied if the decision could have been different had fairness been afforded, as highlighted in the High Court in MZ-APC and the Minister. In the present case, we submit that it could. Had the plaintiff been afforded procedural fairness, there was a realistic possibility of a staged retrofit preserving her tenancy, in situ or proximate lodging maintaining her schooling and lodging, or, at the very least, an enforceable right of return with tailored sequencing. These were rights-abiding alternatives. They were consistent with the family's expressed concerns in the agreed facts, paragraphs 5 to 9, as well as the affidavit of X in paragraph 15 to 18. This concern is reinforced by the expert evidence of Professor Ngion, a leading authority in large-scale remediation and retrofitting of high-density housing. In paragraph 10 of her statement, she outlines the many viable options the defendant could have pursued to retrofit the towers effectively. She also highlighted the lack of a feasibility report to support the decisions being made by the defendant. Without the presence of this expert report, it appears that the defendant has acted on assumptions rather than evidence, a striking example of decision-making divorced from care or scrutiny. The defendant not only failed to consult with the plaintiff, but also failed to consult any experts in reaching this decision.
Counsel, if I can just ask you a question. You're saying at paragraph 5 of your written case, in the oral submission just now, that if there'd been the consultation between the Department of Homes Victoria and the plaintiff, that there was a realistic possibility that the retrofit could have occurred and the right of return could have been brought in. I mean, do you think that's really a realistic possibility? Having read the affidavit of Alexander Garg, it really seems that he was pretty determined on not pursuing retrofitting. What's your response to that?
Your Honour, we submit that the failure was not only to not consult with the plaintiff, but there was also a failure to consult with experts on the matter. Mr. Garg's statement is based off his opinion, and there is no feasibility report to back why this needed to occur. We submit that there were other alternatives, as have been backed by experts in the field, and had there been this pre-consultation with not just the plaintiff, but also with experts at the time, that there would have been a resolution that demolishment did not need to happen and that retrofitting or other alternatives could have been pursued in the meantime.
But also remember, Mr. Garg is a bureaucrat who's required to carry out government policy. And it seems that the demolition of the towers, as well as replacing the old towers with more modern and more convenient homes, it was also part of a broader government policy to increase the supply of homes in Victoria.
Yeah.
So do you think it just seems to me a little bit optimistic that once Mr. Garg is X's problems with the removal and demolition, he's going to effectively change, Homes Victoria are going to change their mind.
Your Honour, before I respond, may I request an additional 2 minutes of time?
Yes, certainly.
Thank you, Your Honour. In response to that query, Your Honour, we submit that there is no evidence on the facts that there are not other alternative public housing complexes that could be considered for this purpose. Considering the significant impact on the plaintiff in this current case, we submit that if the primary reason for this demolishment is extra housing, then Homes Victoria should look to some of the other housing complex that are under their control and not this particular housing complex.
Just to follow up on me to eat into your 2 minutes, I apologize for that. But what happens if Homes Victoria finds that there are no suitable public housing commission flats that can be demolished?
In that case, Your Honour, we submit that they look at alternative ways of including more housing areas without fully demolishing this specific complex, whether that be including annexes or acquiring additional land around this area. We believe that there are other alternatives rather than specifically demolishing this in order to get to this end.
Sure, thank you.
Our learned friends cannot assert that the outcome would have been unaffected by consultation when there is no expert evidence to support their original decision. Unfortunately, Your Honour, the defendant did not take the steps necessary to protect the plaintiff's right. A vulnerable 9-year-old child was left to face the consequences of a careless decision made by a government corporation. This is not a simple administrative oversight. It was a failure to protect this child's rights and well-being. Your Honours, the plaintiff does not ask for special treatment. She asks for fair treatment. Fairness would have meant timely disclosure, genuine consultation, adjustments for disability, and a real consideration of the available alternatives. Those are not luxuries. They are legal entitlements. The defendant denied them, and that denial is material. Accordingly, we submit that the decision was unlawful and that the court should grant relief sought and restore a proper, rights-compatible process. This is not a case about just the law. It is about a vulnerable little girl who deserves more than just to exist in the system. She deserves to have her voice heard and her rights upheld. If Your Honours have no further questions, that concludes my submission.
Nothing further from me, counsel, unless my judges have anything. All right. All right. Thank you. Let's proceed.
Your Honours, this case is not about whether housing should be safe or expanded. It is about whether Homes Victoria acted lawfully when it chose demolition without consultation, testing alternatives, and weighing the rights of those displaced. We submit it did not. To that end, I make two submissions. First, that the defendant failed to comply with Section 38, subsection 1 of the Charter of Human Rights and Responsibilities Act 2006. And second, that this court should look to international materials for persuasive context. Section 38, subsection 1 makes it unlawful for a public authority in making a decision to fail to give proper consideration to a relevant human right. Section 38, subsection 1 has two limbs: proper consideration and substantive compatibility. Neither was met, and I will address each of these points in turn. Firstly, proper consideration. Your Honours, my learned friends at paragraphs 19 and 21 of their written memorandum claim that the decision received proper consideration, relying on Thompson and Minogue to suggest only a broad and general assessment was required. With respect, that misstates the case. At paragraphs 87 to 89, the court held proper consideration must still satisfy the HJ test. Firstly, to identify the rights engaged. Secondly, to consider seriously how they will be affected. Third, to ask whether any limit is justified. And fourth, to engage in structured justification. The phrase broad and general assessment was tied directly to that fourth step, the exercise of justification, not as a license for superficiality of the term proper consideration. Even in Thompson, concerning the parole of a convicted terrorist, the court still required genuine, real engagement with his human rights. And if that was required there for a terrorist, it is certainly more essential here, where the rights of an innocent, disabled, 9-year-old Wurundjeri child are at stake. Our learned friends also say at paragraph 9 that as demolition has not yet occurred, that the plaintiff's rights remain untouched. Your Honours, that misunderstands when rights are engaged. As Justice Bell explained in PJB and Melbourne Health, limits can arise the moment the decision is made, even before the bulldozers arrive. The interference is already baked in. Further, the defendant leans heavily on Mr. Garg's statement. At paragraph 3, he claims the towers are reaching the end of their useful lives. But Garg is a CEO, not an engineer or planner. His statement is precisely the kind of hollow recital condemned in Bear and IBAC. By contrast, the evidence of genuine experts.
Kind of jump in there, sorry interruption. Don't you think you're discounting his expertise a little bit? I mean, yes, he's not an engineer, but he's also CEO of an agency which specifically builds homes. So he's not some sort of average Joe on the street.
Yes, Your
Don't you
Honour.
think that that gives him some weight?
Yes, Your Honour. I agree that Mr. Garg has a better understanding than the average individual, but I draw Your Honour's attention to the evidence of experts with over 20 years' experience in their relevant fields. Professor Guan, who is a structural engineer with over 20 years' experience, stated at paragraph 18A that Garg's claim is inaccurate without having first completed a feasibility study. At 14, she confirms that no such study was done. And at 12, she stresses that a robust feasibility process would have been required before any demolition decision occurred. And further, that Professor Malatesta, who is an urban planner of 2 decades, states at paragraph 6 that dispersal will cause disproportionate harm. And the plaintiff's affidavit further shows between paragraphs 12 to 13 that her family was never consulted. Further, our learned friends say at paragraph 23 that the right contained in section 13, subsection A of the Charter, will only be breached where the interference is unlawful and arbitrary. Your Honours, we submit that the interference with the plaintiff's home is both arbitrary and disproportionate. It is arbitrary because, as Bear and PJB make plain, an interference without genuine reasoning and evidence is capricious. Garg's conclusion that retrofitting was not feasible was reached without commissioning the feasibility study. Guan identified as essential, leaving the decision untethered from evidence. Your Honours, section 38, subsection 1 required a structured, evidence assessment of rights, alternatives, and impacts. Instead, the record shows silence. Silence here is not neutrality. It is unlawfulness. And second, compatibility. The second limit of substantive compatibility, which can be analysed under the proportionalities test set out in section 7, subsection 2 of the Charter. Here, the defendant fails on every step. Subsection A, the nature of the right. The rights engaged cut to dignity, stability, and cultural identity. Subsection B, the importance of the purpose. We accept that meeting standards and increasing supply are serious objectives. But as in Cotterill and Romanes and Loyola and Giles, importance cannot act as a trump card. The plaintiff's home is already wheelchair modified, providing real safety in real time for her today. Stripping a disabled child of that cannot be justified by promises of safer housing later in years to come. C, the extent of the limitation. Your Honours, the impact is profound. This child, with autism and cerebral palsy, is being uprooted from the only safe home she knows. Malatesta warns at 6 that dispersal dismantles support and increases social isolation. This is not inconvenience, it is dislocation. D, relationship between the limitation and purpose. At paragraph 1, our learned friends say that the purpose is to meet standards of safety and increasing supply. But the affidavit at paragraph 7 shows the plaintiff already lives in her modified apartment, very safely. Demolition removes those protections, causing displacement and fracturing kinship ties. We accept that safety is vital, but retrofit could have addressed building issues without stripping away accessibility. On supply, no evidence shows new housing cannot be built elsewhere. Safety and supply may be legitimate aims, but demolition is neither necessary nor proportionate when less harmful options exist. And the defendant has not demonstrated that demolishing this exact tower is the only way forward.
Counsel, let's say that this bench is with you and that there has been a failure of process.
Mm-hmm.
In the end, the decision might actually be justified, right? Ultimately justified when we weigh up all the factors. Can a pure failure of the process trigger the remedy that you are seeking today?
Yes, Your Honour. We are seeking that a final stay restraining the demolition of the plaintiff's home and a declaration that the defendant's decision to demolish was unlawful and an order as to costs. And these can all be achieved by demonstrating that, Your Honour.
But ultimately, under the Charter, isn't it open to this court to find that there's been a failure to consider that there has been a breach on process, but the court might still, well, the court can look to the materiality and what the end goal is, or what the end effect will be?
Yes, Your Honour. As I discuss in my analysis of Section E of subsection 7.2, Section 7, subsection 2, apologies, Your Honour, we will find that there is, confirmed by experts, a less restrictive means available. And under that analysis, we submit that the court should not find that the decision should be allowed to continue. And moving on from that point, at paragraph 26, our learned friends claim that retrofitting would be no less disruptive. With respect, that is assertion, not evidence. Garg speculates at paragraph 6 about years of relocation when retrofitting. However, Guan at 18C confirms that retrofitting can be staged, reducing disruption compared with wholesale demolition. Staggering retrofit would mean less people have to be displaced at any given time, meaning the plaintiff would not be able to get lost in the displacement, being one of the 10,000 being dislocated, but instead becoming more of like 1 out of 100. Having less residents displaced at any given time would potentially allow the process to be far more personalised and tailored to the plaintiff's individual needs and provide Homes Victoria with more time to find her suitable accommodation to meet her safety and independence needs. At paragraph 18B, Guan explicitly states, retrofitting offers a less restrictive means reasonably available to achieve the objectives. Your Honours, ignoring retrofit when it is feasible and less harmful means demolition simply cannot be called necessary. And finally, the balance does not tip, it collapses. On one side lies the plaintiff's reality, the loss of her specially modified home, the fracture of kinship and culture, the disruption of care and therapy, and the loss of her safety and independence. On the other, only abstract promises of safety and supply to support generations in many years to come. The Charter does not permit sacrificing concrete, immediate rights for speculative long-term benefits. When weighed properly, the scales are not even close. Your Honours, I turn to my second submission, that international materials provide persuasive context, which only further underscores the defendant's failures.
Counsel, if I can just jump in here, in the version of your written case that I've got, does this include the international materials?
Your Honour, we submit that given the 5-page limit to our written submissions, that we as a team chose to submit the most pressing arguments.
It's yes or no, counsel?
No, Your Honour.
Because, as I was going to say, if you would like to rely on those, you can with leave of the court. Do you seek leave?
Yes, Your Honour.
Right, leave is granted.
Thank you, Your Honour. At paragraphs 27 to 31, my learned friends downplay the relevance of international law, saying that Article 17 of the International Covenant on Civil and Procedural Rights concerns mass ejections, and that Section 19, subsection B of the Charter does not extend to housing. With respect, that misses the point. Section 32, subsection 2 of the Charter expressly directs this court to consider international law when interpreting rights. These instruments set the baseline of a rights-respecting society. The Convention on the Rights of the Child make a child's best interests a primary consideration. Here, they were sidelined. The Convention on the Rights of Persons with Disabilities demands accessibility and adequate housing. Demolishing a modified unit without adequate replacement breaches that. And further, the United Nations guidelines on development-based evictions require consultation and testing of alternatives before displacement. Guan at 14 confirms neither occurred. Measured against these baselines, the defendant's process falls far short. Your Honours, as previously stated, we seek the following orders: a final stay restraining any demolition of the plaintiff's home, a declaration that the defendant's decision to demolish the tower was unlawful under Section 38, subsection 1 of the Charter, and unjustifiably limited the plaintiff's rights. And finally, an order as to costs in the plaintiff's favour. Unless I can assist the court further, those are my submissions.
Thank you, Counsel. That was very helpful. Are the respondents ready to commence their submissions?
Yes, we are, Your Honour.
All right, please proceed, Counsel.
May it please the court, we do not underestimate the weight of this decision by Homes Victoria to retire and demolish these towers. However, the administrative law principle of procedural fairness is not an obligation here because redevelopment is a broad policy decision and not an adjudication of individuals' rights. Furthermore, these towers that X resides in and that hold so much value for X are unsafe, outdated, and cannot sustain dignity in the long term. In choosing redevelopment, Homes Victoria exercised its mandate lawfully, proportionately, and always with the residents' welfare in mind. And Your Honours, we respectfully seek that this proceeding be dismissed. I now turn Your Honour's attention to submissions A, paragraph 4 of our written submissions. We submit that Homes Victoria was not obliged to provide X with an opportunity to be heard. This is because the decision formed part of the development power Parliament has expressly conferred under the Housing Act of 1983 of Victoria. In examining this Act, Section 15(1)(a) empowers Homes Victoria to develop any land vested in it, while Section 6(1)(a)(3)(i) confirms the Act's objectives of promoting the orderly planning, assembly, and development of land. And Your Honours, it is...
Counsel, both of those sections go towards the development of land. Here we have a building tower. We have a constructed public housing. Does Section 15(1)(a) and the other section you mentioned, do they extend to existing structures?
Yes, Your Honour, they do, and we will make further submissions on that, relying on the authority in the case of Berry, later in my submissions as well. And in focusing on the development aspect, Section 4(1) defines development to include the construction or demolition of a building on the land. So, Justice Swamy, in regards to development, we submit, because Section 4(1) also includes demolition of a building on the land itself, Homes Victoria does have that power. Your Honours, it is important to note, in the Housing Act, there are also potential conflicts in the objectives as well on face value. In particular, Section 6(1)(a) of the Housing Act states, and I quote, to ensure that every person in Victoria has adequate and appropriate housing, end quote. However, on the other hand, Section 6(1)(g) and (h) state its objectives to seek participation of tenants and to promote consultation on major housing policy. This language is merely aspirational. And in unpacking this conflict between Section 61A to Justice Richard's judgment in the case of Berry v. Holmes Victoria number 4, heard in 2025, the 169 judgment of the Victorian Supreme Court. With Your Honour's permission, may I please dispense with formal case citations?
Yes, please do.
Thank you, Your Honour. Justice Richards said, in considering the clash in the objectives in the Housing Act, and I quote, "The objects of the Housing Act are multidimensional, which may conflict. The Housing Act leaves it to Homes Victoria to determine how to best achieve its objects and what weight to give competing considerations." And Your Honour, we submit, if we examine the language of Section 61A stating to ensure that every person in Victoria has adequate and appropriate housing, compared to 61G and H to seek and to promote, Homes Victoria rightfully gave consideration to ensure that every person in Victoria had appropriate housing, which informed their decision to demolish and retire and demolish the land.
Counsel, if I understood the applicant's arguments on the point of Berry, the first was that we've got a very specific set of circumstances here with the applicant, and that those very specific set of circumstances must be taken into account in coming to a determination. And then later was suggested that in Berry there was a careful consideration with experts and feasibility studies, etc., which did not occur in our current matter. Are we not to distinguish from Berry then?
Your Honour, we submit that the case, the plaintiff's position of X and Berry are extremely similar because of the fact that both plaintiffs had cerebral palsy. They were living in a modified home, and the tower's condition were deteriorating as well. And just on the point of our learned friend's statement, which stated that a feasibility would be required for a feasibility study, rather, would be required for demolition, and consultation with experts would be required. In an ideal world, this would be the case. However, the law, and especially in the case of Berry, that statement does not stand.
Thank you. And just to follow up on that, so you suggest that in Berry there was a individual with cerebral palsy as well. Was that discussed in the judgment? Can you point me to the paragraph where I can find that information?
Yes, Your Honour. May I please have 1 second to confer with my notes?
Perhaps your junior can provide it to us later. You can continue.
Yes, Your Honour. Thank you. So, Your Honour, in establishing these objectives, Section 15 empowers redevelopment, Section 4 defines demolition as redevelopment, and Section 6 sets its objectives. It was Parliament's clear objective to ensure that Homes Victoria had the decision-making ability to ensure the welfare of the residents were kept in mind. And we further submit the redevelopment decision here is a direct exercise of that statutory power. If it was not an adjudication, it was not an adjudication of excess tenancy rights, but rather the lawful execution of a broad renewal program to replace unsafe towers with modern, sustainable housing consistent with the Act's objectives. In the interest of time, Your Honours, I now turn your attention to Submission B, paragraph 6 of our written submissions. My second submission is that Homes Victoria's decision did not affect any legally recognised rights or interests of X. Your Honours, this is a matter of law, and in Berry and Homes Victoria, the court was clear. The decision to retire ageing towers formed a part of the statutory redevelopment program. It was not a decision that affected the tenants legal rights in their individual capacity. And that principle applies here squarely. And we submit this because there has been no termination of X's tenancy and no possession proceedings have been brought forward and no step has been taken that would alter the enforceable entitlements of X or any other tenant. Second, X's rights remain intact under the Residential Tenancies Act of 1977, Victoria. And third, the decision concerns a future redevelopment plan, not present interference, as the court observed in the case of Kesey and the Director of Housing. The mere making of a redevelopment or possession decision cannot itself limit tenancy rights or charter rights. And we submit that this is the case in this matter as well. It has not limited X's tenancy rights or charter rights. It is only at the point of implementation, as stated in the case of Kesey, through statutory processes that individual rights are engaged. In this case, Your Honours, X has not been evicted from her tenancy agreement, and that tenancy agreement stands, and she retains every protection the law affords. To categorize the protection the law, to categorize the redevelopment decision, rather, as an interference with X's rights is to confuse policy direction with the legal effect that I've just outlined. And Your Honours, we therefore submit that X's claim fails at this threshold stage. There has been no present impact on any of X's legally enforceable rights, and there is no basis for the procedural or substantive protection that the plaintiff X seeks in this matter. I now turn your attention, Your Honours, to submission C, paragraph 10 of our written submissions. And we submit that Homes Victoria was not obliged to provide X with an opportunity to be heard. And the governing case on this, and we rely on, is the case of Berry and Homes Victoria. And in particular, paragraph 10 and 11 of our written submissions. It was held in this case that although the presumption of procedural fairness is broad, it does not extend to statutory powers exercised over members of the public in their public capacity. Procedural fairness only attaches where a power singles out, rather, a particular person and directly adjudicates their rights. But where
Counsel, I'm sorry to interrupt you. What do you say to the point, and I think your learned friends were driving at, that X is uniquely affected by the decision because she's so uniquely vulnerable?
Your Honour, we understand that X will be affected by the decision. However, so will the 10,000 residents living in the tower. They will be affected as well. Unfortunately, due to X's circumstances, this puts particular hardships on her, but X forms a part of the 10,000 people in the tower subset. Therefore, it will be 10,000 people being affected, and X is not being particularly adjudicated on or particularly directed on in Homes Victoria's judgment. And Your Honour, with your permission, I would also like to address one of the points raised by our learned friends in relation to the case of Kiowa and West.
Yeah, please.
Your Honour, our learned friends stated that in the case of Kiowa and West, and I refer Your Honour's attention to paragraph 1 of our learned friends' submissions, and I'm examining footnote 5 in particular, that the notion of procedural fairness helps in, and I quote, the greater the impact, the greater the content of fairness that is required. But we submit, Your Honours, the key question, as established in the case of Berry, is who is being impacted by this decision? Is it an individual, or is it a public, or the large members of the public?
I'm sorry to interrupt again, just so I can make sure I'm following your counsel. You Do you dispute the way in which your learned friends have cited Kiara and West? Is that why you're referring to it? I mean, do you
Yes,
think they've miscited the case?
Your Honours, we submit that our learned friends have cited the case of Kyogo and West, however,
Mm.
have miscategorized the definition and the application of procedural fairness. And this is because, Your Honours, in Kiowa, it concerned the deportation of a single family where the government relied on undisclosed allegations specific to Mr. Kiowa. This was an actual adjudicative decision made against Mr. Kiowa. But in this case, rather, this decision that Homes Victoria made extends to the entire 10,000 residents, and it was not specific to X. And Your Honor, with your permission, may I please seek to extend my time by 2 minutes?
Yes, that's fine.
Thank you, Your Honor.
I'm going to also eat into your 2 minutes. So you're suggesting that Kyo, because it's one individual family, there should have been high regard to the individual circumstances. Because it's 10,000 people here, no regard needs to be made to individual circumstances, which is fine. I might be able to accept that. But surely there should have been a consultative process then, because there's 10,000 individuals being affected, or some other processes which might fall short of Keogh and the procedural fairness afforded there, but should definitely be greater than what has been afforded in the current circumstances.
Your Honors, we do acknowledge that this circumstance is difficult for X. However, the reason why Homes Victoria made such a quick decision to retire and demolish is because the state of the tower is deteriorating quickly. There are structural issues and there is fire protection issues. The physical condition of the tower is deteriorating. And our learned friends stated that there should have been consultation for X because of her circumstances, and that X is already safe in this matter. So consultation and feasibility should have occurred. However, Your Honor, we submit that due to the deteriorating circumstances of the tower, X is not safe, and neither are the 10,000 residents. So therefore, consultation wasn't warranted in this scenario.
Right, but even with that consultation, surely experts' feasibility reports, because how have you come to the conclusion that it's unsafe? Surely in that process itself, the 10,000 people should have you should have had regard to those 10,000 people.
Your Honor, we do agree that taking into account the circumstances would be ideal. However, Homes Victoria has sought to do this in the relocation assistance that they have provided the residents. They needed to make this decision for their safety, but they are taking into account, they consider the circumstances
But,
after this decision has been made.
but counsel, and I'm sorry to eat your time further, don't you think you're sort of putting some gloss on the facts by saying a decision had to be made quickly because the apartments are unsafe in your answer to Justice Swamy? I mean, does the evidence actually support that conclusion, or is this an inference that you're making?
Your Honors, due to the culmination of the issues that Professor, sorry, apologies, that's the CEO of Homes Victoria, rather indicated, structural issues, fire protection issues, the dwelling amenity issues. We submit that if there are so many issues with a tower, there needs to be a decision made quickly. And there are numerous individuals in this tower, such as X, who are particularly vulnerable. Therefore, we need to look out for the interests of X in terms of her safety first. And if the situation arises where we can take into account their circumstances, Homes Victoria would seek to do so. And that is exactly what they have done in the relocation assistance that they have provided to these residents. They haven't dispersed them and allocated alternative accommodation quickly. They have ensured that they have consulted and understood their needs and relocated accordingly.
Councillor, just one final question on it. Did the CEO of Homes Victoria consult with anyone prior to making the decision?
Your Honor, on the facts, it has not been made clear.
Yes or no on the facts?
No, Your Honor, they haven't. And Your Honor, in the interest of time, I will now pass on to my learned junior, who will be discussing submissions D, E, F, and G, and in particular, the human rights and international human rights obligations. If I may be of no further assistance to the court, these are my submissions. May please.
Thank you, counsel. Thank you very much. Georgina, ready to go?
Your Honours, if I might start by addressing Justice Swamy's question about cerebral palsy, it's paragraph 78 of the judgment in Berry. There's a mention of Mr. Berry's disability. Further context is found in the statement that the Supreme Court releases on the 24th of January 2024, which states that Mr. Berry has cerebral palsy and is cared for by his mother. Thank you, Your Honours. Your Honours, I might turn then to submissions D and E of our written memorandum. We submit that if the procedural fairness would give X the right to be heard, then X's right to be the contents of this hearing would not make any meaningful difference on the decision the Homes Victoria made. X would only be entitled to speak to the impact of her rights and interests. We accept that these rights are not absolute. However, the fact that the more rights have been impacted as well as detriment show that X would only be entitled to speak about the way that this demolition decision affected her as an individual. She would not be entitled to speak to any alternatives or any other reasonable means available to Homes Victoria to take as a course of alternative action. With then the contents of this procedural fairness, any hearing being fairly hollow, there'll be no material effect on the decision that Homes Victoria made. Justice Darcy points out correctly that Mr. Garg seems adamant on taking this course of action on demolishing the homes as a matter of increasing housing supply and quality. With reference to the fact that as the contents of any hearing would be if limited to the impact that X had received by the demolition decision and the effect it would have on her rights and housing, and the fact that they would not be able to speak about any alternatives, there was no reasonable expectation that this hearing would have a material effect on Homes Victoria's decision. The submissions of that effect would have no effect or consequence on the way that this decision was held as a matter of advancing a policy decision. Your Honours, if I might turn then to submission F, our next submission is that the demolition decision adheres to any obligation Homes Victoria had under the Charter of Human Rights and Responsibilities Act. Section 38 of the Charter imposes dual obligation on public authorities. The first, to give proper consideration to the rights contained in the Charter when making a decision, and the second, to ensure that decisions are not incompatible with human rights. The defendant submits that proper consideration was provided. Your Honours, if I might refer your attention to the case of Thompson and Minogue, at paragraph 89, Justices Cairo, McLeish, and Nile unanimously held that the test for proper consideration is that a broad and general assessment of whether the impact that has held is reasonable must be considered. Your Honours, we submit that this is the case. Even if our learned friends pose this as a more strict test, using the same case, that the defendant must understand which rights are relevant, seriously turn their minds to the possible impacts, identify countervailing interests and obligations, and then balance these, we submit that Mr. Garg still satisfies this requirement. If I refer your Honour's attentions to paragraph 8 and 10 of Mr. Garg's statement, he carefully acknowledges the detriment caused and weighs them up against the overall benefits of the demolition decision. Mr. Garg understood in general terms that implementing the redevelopment plan would interfere with renters' homes and was aware that...
Accept your argument here that paragraphs 8 and 10 suggest that there's a broad statement there, but the judgment you took us to in Thompson suggested a broad and general assessment. So there's a difference here, right? Paragraphs 8 and 10 go to, it's a broad and general statement by the CEO, but my understanding still is that there was no assessment that actually took place, whether internally or externally, in arriving at the conclusions that the CEO has arrived at.
Your Honour is correct in identifying that we have nothing on the facts to identify whether internal assessments have or have not been made by Homes Victoria. However, as an experienced bureaucrat and the CEO of Homes Victoria, we would submit with respect that Mr. Garg is in a position as an expert of managing homes across the state to assess from his own basis the interest in advancing this policy decision
But
and
but
the
Mr.
prevailing
Louis,
interests.
I'm sorry to interrupt, but I think what Justice Swamy was asking you is not, is Mr. Garg able to do an assessment and is he particularly qualified? It's more, did he actually conduct the assessment? And it's just not clear in the facts.
It's
At least
unclear.
not clear in the evidence as far as I can see whether he actually did. So we appreciate your guidance on that.
We submit that it is unclear on the facts, and that all we would have to submit is that he is in a position to have made that assessment, and that we would characterize that he has.
But Mr. Louis, your written case says at paragraph 22, and I'm sorry to harangue you in this. It says Mr. Garg's affidavit shows a careful evaluation of the decision's impact. Do you do you maintain your argument that a careful evaluation or assessment was made?
We do maintain that there is a careful evaluation. Mr. Garg was in a position where he's been directed by the government to increase housing supply and safety, and he carefully evaluates, as the test requires, whether the demolition decision is an appropriate way of achieving this, and he understands the impact it would have on the renters. But we submit that he does make this assessment based on his authority as the CEO of Homes Victoria.
To belabor the point a little, in Thompson and Minnow, um, was there any external assessment? Because that is the basis on which you asked this court to make its decision regarding this particular point.
Of course, and Thompson and Minot concerned strip tests and urine tests made by inmates of a prison cell, and that was held that there was needed to be kind of a general assessment there, but that was made by the staff in that case. And if I could refer your attention to paragraph 318 of that judgment, where it was found that the strip searches were arbitrary, and they had not made that general assessment. However, it was held that they needed to be that assessment was accepted that it could be made by the staff in that situation.
Thank you.
Your Honours, I'll now turn to the second element of the Section 38 of the Charter, the obligation to ensure that decisions are not incompatible with human rights. With focus on Section 13A, this may only be breached where the interference with one's home is unlawful or arbitrary. And we submit that no breach has occurred. There's been no actual or material breach of the right to have one's home not interfered with. It's important to note that this is merely a decision made by Homes Victoria, rather than an actual forceful eviction or demolition made so far.
But excuse me, counsel, I'm sorry to interrupt again, but I'm just looking at your written case. Your analysis about breach of rights focuses solely on the 13A right to not have one's home interfered with, but there doesn't seem to be any analysis on the cultural rights in Section 19. Is your position that they're not breached at all?
We submit that these have not been breached, and we can use the international law to make reference to this. However, if I could seek leave to depart from our written space to deal with this question, if you prefer.
Well, let's just deal with that when we come to it. I don't want to sort of get you out of ordinary submissions.
Thank you, Your Honour. With reference to the case of Kesey and the Director of Housing, it was held that a decision to evict tenants in this matter by proceeding to VCAT for a possession and termination order do not affect the tenant's rights. The tenant can only be evicted as a result of the decision by the tribunal. Similarly, Homes Victoria has not yet evicted anyone and does not have the power to do so without VCAT. The mere making of this decision could not deprive X of her property, nor could it unlawfully or arbitrarily interfere with her rights. Thus, X retains her rights under the Residential Tenancies Act, and it cannot be said that this has been interfered with by the decision. Nor can it be said that this decision was unlawful or arbitrary. If I refer your Honour's attention to paragraph 55 of Minogue, the Honours held that a decision will be arbitrary when it is capricious or unjust or unreasonable in the sense of being disproportionate to the legitimate aims sought. In this matter, Homes Victoria immediately notified tenants as soon as the Victorian government made this decision and offered assistance in relocation. This was again proportionate to the aim of achieving safer and better quantity of housing. Your Honours, if we may respond then to the other rights that our learned friends seek to raise, the right to the best interest of the child in Section 17, we submit that this has not been breached. It is in X's best interest to live in housing that meets modern fire safety standards, modern disability standards, structural security standards. Your Honours, if I might then turn to Section 19.2 as Your Honours questions, which raises validly the right to cultural enjoyment of First Nations people. However, the right that our learned friends submit under 19.2D is only affected when these cultural practices have a connection under traditional laws and customs. Under traditional laws and customs, there is no proprietary interest to the North Melbourne Towers, and we distinguish on this point.
No, yeah, look, I take your point, but they're not stopping them, say, engaging in traditional customs, such as like performing rituals. However, don't you think the fact that they're being separated from their traditional land and waters is arguably an infringement of their cultural rights? I don't think it's clear cut, so I'm interested in hearing your position on that.
Your Honour, I believe that is quite a vexed issue, and we would submit that this validly may have breached the Charter. However, if I refer Your Honours to our next point in our submission, where there are breaches of the Charter, including the right in Section 19.2, this still may be excused as a matter of policy. Your
So
Honours,
I don't mean to put words in your mouth, Council, but just so I'm clear, your position is it has or it hasn't been breached. It hasn't been breached, say, but if it has been breached, then it's just a limitation. Is that what you're arguing?
correct, Your Honour.
All right, thank you. Please move on.
Your Honour, we submit that even if it had been any of these rights have been breached, under Section 7.2, there will be a lawful excuse. There is no reasonably available method that is less restricted that would achieve the policy aims of this decision. Retrofitting would still take years, regardless of the merits of this decision, and would still involve residents being relocated across the state. Professor Malatesta stresses that there is a lack of housing supply to ensure that the residents are relocated together. There would still be an intolerable burden on their community. However, at the same time, we would not address the fact that this demolition decision will create a 10% increase in social housing and triple the number of residents, addressing a current housing crisis this state faces. Your Honour,
I'm sorry to interrupt you again. What do you say to the proposition I think Junior Counsel for the applicants made, which is that yes, it's a noble pursuit to increase housing stock, but it didn't have to be done at this location with these particularly vulnerable people. What's your response to that?
my response is, on a practical sense, these housing complexes occupy a huge amount of land. They house 10,000 to 30,000 residents. It's not a simple step to say that, or you just simply can find more land to build massive housing towers, especially when land seems to be at a premium at the moment.
Is it not then also not a simple step to say we've simply demolished them when there are already people living there?
I think that comes down to the fact that when there is an exception made, it has to be reasonably available. And I think this is the most reasonably available with reference to the fact that there is a lack of adequate land on which they could develop new towers. The fact that if they were to not demolish this tower and maintain the status quo, they would have to engage in a costly and time-consuming retrofitting, which would not engender the policy of increasing social housing. So I think at the present, Homes Victoria has the opportunity to hit two birds with one stone, increasing social housing and increasing the quality of that housing as well, which I think they should be reasonably expected to take. Your Honours, if there are no further questions on this point, I might take your attention then to the international covenants. Your Honours, the rights under Section 19 are largely based on the Universal Declaration of the Rights of Indigenous People. If I refer Your Honour's attention to the explanatory memorandum, it states that Section 19B is based on Article 25 of the Declaration. Yet this article itself concerns spiritual rather than proprietary interest in the land. And we reject then that this right is extended to public housing in this matter on the basis that there is no direct correlation between the housing itself and the cultural practice, despite its proximity. Your Honours, we also raise Article 11.1 of the International Covenant on Economic and Social Rights, which states that there is a right to adequate housing. Currently, it's not disputed that the North Melbourne Towers fail to meet modern fire safety standards, structural safety standards, and modern accessibility standards. And it is in the best interest of children, of those with disabilities, as our learned friends raise, to address these deficiencies and engender the right to adequate housing. Your Honour, these are our submissions today. We submit that there was no obligation to afford ex procedural fairness, and that no rights had been breached. In the alternative, if there had been breached, the overall policy of increasing social housing supply could not be reasonably attained elsewise, and we therefore ask the case to set aside this matter and dismiss this hearing. Thank you.
Thank you, counsel. Did the applicants wish to make a rebuttal?
Yes, Your Honour.
Please proceed.
May it please the court. Our learned friends assert that the judgment of Berry applies as Berry also has cerebral palsy. However, on the facts of the Berry case, Berry has mild cerebral palsy. In comparison, the plaintiff suffers from a severe case of cerebral palsy, so much so that she is confined to a wheelchair. This distinguishes the Berry case as the impact of cerebral palsy on X has a higher impact, which has contributed to the specially modified house that she currently lives in. Further, our learned friends have attempted to recategorize our application of Kiowa and West by asserting that Kiowa involved an individual family. In the present case, demolition will severely impact individual and legally recognized rights of the plaintiff, those rights being the rights of a child, the rights of disability, and her rights as an individual who is of an Indigenous background. Finally, our learned friends have stated that it is unclear on the facts as to whether a full feasibility study has been commissioned. However, at paragraph 14 of Professor Guan's statement, she has stated that no such study has been commissioned or publicly released. Any decision made on an assumption and not on expert evidence cannot be justified. Where justification is absent, unlawfulness follows. Furthermore, onto the point in regard to retrofitting and the fact that it will most likely be more costly. At paragraph 15 of Professor Guan's statement, she has pointed to international and domestic precedents that demonstrates that towers of comparable construction have been successfully retrofitted with significant cost and environmental benefits. On that basis, we submit that the decision to demolish should be quashed. That concludes our submission.
Thank you, counsel. Did the respondents have a rebuttal?
Yes, Your Honour.
Please proceed.
May it please the court, our learned friends have submitted that in this case, the effect of the redevelopment, demolition, and retiring decision will affect the rights of X as an individual. It will. However, it will also affect the rights of 10,000 other individuals in the housing complex. And as outlined in my submissions, it is unreasonable and it is not viable to understand and to invite 10,000 individuals and consider the impact on their rights. Furthermore, our learned friends have stated that Professor Guan has said that no feasibility study has been commissioned or released by Homes Victoria. Your Honours, there is a very clear reason why that is. It is one, because of the fact that a feasibility study was not required because in the CEO of Homes Victoria's judgment in the deteriorating condition of the tower, and I point you, Your Honours, to the noise issues, thermal performance, sustainability, structural, waste and recycling issue, and physical condition of the tower, a feasibility study would not have changed the decision, and the decision of retiring and demolishing these towers were the only way to achieve the safety of the residents and also to address the housing supply issues which Homes Victoria is facing. The CEO of Homes Victoria is an experienced individual, and they took into account the alternatives that they had in making this decision. And they have rightly done so, abiding by procedural fairness and ensuring the safety of the residents and the housing supply demands of the area are met. Your Honours, these are our submissions. May it please the court.
Thank you, counsel. Well, we thank the parties for their submissions. I think we'll reserve our judgment. Court will be adjourned. Now, I think what happens now, and please correct me if I'm wrong here, you're probably more across the rules than I am. I think we send you out of the room, we have a bit of a chat amongst ourselves, and we call you back and tell you who won. Does that track with what you understand?
That is.
Cool, okay.